A debt recovery claim is when a creditor is owed money by a debtor. We commence by issuing a letter of claim to the debtor, which gives them a final chance to pay within 30 days. If no response is received and the claim is not defended, then we can make an application to the court. After making the application to the court, we'd expect to hear back from them within 4 to 6 weeks with the sealing of the documents where they serve it on the debtor. Once the claim is served on the defendant, if they do not respond or acknowledge the claim, then we make an application for default judgment. By the time the judge is reviewing the papers, if nothing is still received by the defendant at that date, then we can obtain default judgment, which is an order against the defendant ordering them to pay. Once we get the default judgment, we can then consider enforcement options. If the claim is defended, then the claim is allocated to a track. If the claim is below £10,000, then it's allocated to the small claims track where legal costs aren't recoverable, so it's not usually economical to have a solicitor on board. If the claim is above £10,000, then it'll be allocated to the intermediate, the multi or the fast track, where costs are recoverable up to a certain amount. How quickly the claim runs from there on will depend on the timing of the county court. The court will then issue various directions which detail how the different stages of the court process will happen and when they will happen from there on. There are several stages that need to be satisfied before a claim can actually reach the final hearing. These stages include disclosure, witness statements, expert evidence and actual trial preparation. The way in which documents need to be served on the other party and filed with the court are very particular, and any missed deadlines or wrong formatting can make that party suffer cost consequences. If you're looking for help as to how to navigate the court process and debt recovery, then please get in touch.